Brandeis has this wonderful insight of states as laboratories of experimentation. Now, what he was referring to was state legislatures as the laboratories of experimentation. And I think there are very few people that think he's wrong about that. You have a new problem like education equality, data privacy, opioids. No one knows the answer, so we try different things. I think the thing Emily and I are both trying to get people to think about is remember that our state courts can also be laboratories of experimentation. And one thing that those experiments, that trial and error can do, is sometimes the trial and error will help us realize there really are 3 or 4 different approaches. They're all equally strong. They all have kind of equal vices. There really is no winning insight that ought to be nationalized. Other times, you will generate a consensus. You'll generate a winning insight that ought to be nationalized. And Professor Zackin and I have not talked about this, but I suspect we both agree that education equality and education funding is very tricky. It's a very tricky thing to sort out. We know we've had national legislation with economic support and some some standards, but I probably am on the side that says we're still looking for that magic eureka insight that is worth nationalizing. It's not because we don't appreciate the very serious equity problems, but sometimes if you nationalize too early, and this is actually the thesis of my chapter in 51 Imperfect Solutions about school funding, if you nationalize too early, you run the risk of losing by winning. In other words, the national standard, because it's national, because it has to apply to 330 million people, thousands of school districts, actually might be too low. It might be too ungenerous, but because it's a national rule, people will hesitate to go beyond it.
But I think one of the really important things to remember is that when we focus on the second shot, one thing you could think is, well, it's secondary, right? Our real values, our highest principles are in the Bill of Rights. And when you read that, education's not in there. And in fact, this is what the court says in Rodriguez. We read it and we don't see education. And so I think from that, people have concluded, well, I guess education rights aren't among America's really most cherished rights. Really, what Americans want is just being left alone. So the Bill of Rights is sometimes described as a list of thou shalt nots. The state has to leave me alone, let me say what I want, let me practice my religion, not search my house, just keep government away from me. And some people think, well, okay, maybe these things are in state constitutions, but surely that's secondary. But in fact, one of the things I argue in my book is that it's not secondary at all. This is a product of America's political history, that we had states before we had the US Constitution, and it was these states that were providing goods like education. And so if you wanted to ensure that there was a public education system, you would go to your state and say, please set that up. In fact, states do, and especially before the 1930s, did an enormous amount of social policy provision. And so it made sense that these rights would end up in state constitutions. This is not to say that they're lesser rights, that they mean less to Americans than the rights in the federal constitution. It's simply that states were the ones doing this kind of governance. And so the constitutions of these states then reflect these demands for goods from government.
When you read the Declaration of Rights of 1776, you're looking at a bridge from the hundreds of years of Anglo-American development to American constitutional law itself. That document, you have to imagine how exciting it was to be present at the dawn of the making of modern constitutions. We take constitutions for granted today. Virtually every country has one. But in the 18th century, it was unclear exactly what you were doing when you wrote a constitution. So these folks in Williamsburg set about that task, wrote a Declaration of Rights, frame of government, and then they really launched the ship of constitutionalism in a very real sense. So having adopted the Virginia Declaration and frame of government, quickly this idea spread. The other colonies, emerging states, were also writing constitutions, and the Virginia document was, in that respect, very influential. It was then ultimately influential on the Federal Bill of Rights, very much framed, indeed, mostly the work of James Madison, who at age 25 had been a member of the Virginia Convention of 1776. He was there present at the creation. Indeed, this Virginia document would have to be counted, I think, as on the top 10 list of the most important Anglo-American constitutional documents of all time. It even influenced the French Declaration of Rights of Man and the Citizen in 1789,